are still running with our top story, which is, of course, today was the second and final day of that hearing where South Africa took Israel to the International Court of Justice, alleging crimes of genocide against them. I do have with me SABC senior reporter in studio with me, Canny Maphanga, alongside Wits School of Governance lecturer Dr. Thelela Ngcetane-Vika, as well as UKZN International Law lecturer Christopher Gevers. So, Doctor, I mean, let's listen to this. On the relationship with Hamas, South Africa, on the assertion that South Africa's legal team is representing Hamas, the South African team actually took umbrage to that, saying it is without fact and strongly rejects that assertion. And of course, this has been quite the order of the day, where the Minister of Justice has had to come up and explain and reiterate time and time again that South Africa is not representing Hamas, did not take Hamas to the ICJ, but in fact the acts of Israel against the people of Gaza.
I mean, it has to be expected. To build on what Christopher was saying. There was a lot of creating a new narrative, and also what I would term whataboutism. And one of those, it sort of landed well with their strategy, is the relationship or the historical political relationship between South Africa and the Palestine, and locating it with Hamas. So it was expected. It's a strategy to diminish the value, and to some extent, I mean, I find it insulting to say the least to the legal team, insinuating that they are representing Hamas. In other words, South Africa, it could be inferred that South Africa is on a proxy legal case for Hamas. So that must be condemned, because with all the challenges and strengths and weaknesses of the case, but it must be said that from an international law perspective, South Africa took a stance, and a very important legal stance that I make a submission that history will look at it very kindly. So that point really must be dismissed. I also wanted to make another point, if you may allow me, because I don't know how much time I have, that one of the weaknesses of the cases of Israel today, as much as their case hinged largely on self-defense, and I think the judges will have to puzzle around that. But there was also a witness of deliberately obfuscating the cause and effect of, genocidal statements that are made by politicians, and then trying to diminish them to a level of these rhetorical statements that politicians usually make. And I thought Ngcetane-Vika did a sterling job on this part yesterday, piecing it bit by bit. And we can't then really dispute the fact that words matter, even so when they are coming to senior politicians. So, and they can potentially influence the posture, the attitude, the brutality of soldiers on the ground. And then it goes back to intent, that space of intent. So I thought, let me quickly make that point before my time ends. Thank you.
Absolutely. Thank you, Doctor. And if you can just on the back of that, Christopher, I mean, we know the issue of jurisdiction there, and of course, international law was a key focus in this case, with of course, the Israeli team saying basically South Africa enjoys ties with leaders, with Hamas leaders, and they've been seen with some of them here in South Africa. And also, they said that the court had to prove plausibility in that it is sufficient that the obligation of South Africa to act to prevent genocide, or the right of South Africa to seek compliance by Israel with its obligation under the convention not to commit genocide, and also to prevent and punish genocide and related prohibited acts under the convention be plausible. Talk to us about that, Christopher.
Thanks. I think it's very important. I mean, we can dismiss as rhetorical the suggestion that we're acting on behalf of Hamas, but it's a dangerous statement, and we have to understand its underlying grammar, right? So this grammar suggests that there are civilized states in the world who have working judicial systems who we should trust to basically police themselves. And then there's states like South Africa who are associated with Hamas. And we saw the same thing come out at the beginning of the conflict, suggesting there's barbarism in the world and civilized, and this is a war between the lightness and the dark. This is deeply colonial language. It has a long history. And the audience for this language is not us, it's the West. And I think we should be very wary of dismissing it as simply rhetoric. It is intended to impugn the ability of not just South Africa, but other states who aren't seen as civilized to bring cases to the International Court of Justice. It also has a dark history in terms of suggesting South Africa isn't able to bring its own case. So when we protested apartheid, we were told we were just the lackeys of the Soviet Union. When we bring a case under the Genocide Convention, we said we're the lackeys of Hezbollah. So there's a dismissal in this that has a deep, dark history. I think we should be wary, as much as in this context you might say it's rhetoric, I think we should be wary of its underlying grammar and its history.
And of course, I wish we had time so we could discuss the geopolitical ramifications and what happens next. But unfortunately, we are out of time. Doctor, thank you so much for your contributions. Christopher, thank you so much for joining us. Canny, thank you so much for a great update there. I suppose we're just going to have to wait and see what happens from now. That was SABC News reporter Canny Maphanga, Wits School of Governance lecturer Dr. Thelela Ngcetane-Vika, as well as UKZN International Law lecturer Christopher Gevers.